It does. Welcome again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters. It's our understanding that if you have a better understanding of the law, it puts you in a better position to be prepared to protect yourself, your family, and your business regarding law matters. As we present various topics, you may decide to handle some issues yourself. If you decide to enlist professional counsel, you'll be better prepared, and as a result, so will the professionals you select. Our goal is to save you time and money and to achieve the best possible results. As always, we want to, again, welcome and thank Attorney David Bizarre from the Bizarre and Associates Law Firm in East Providence, who continues to provide us with legal information and his insights and some wonderful anecdotes in each session. So today, how to evaluate a lawyer. Finding the right lawyer for your needs may seem like it's an intimidating process, but remember, you are the consumer. And as with any other consumer transaction, doing your research is key. Admittedly, if you're in an accident, you could be besieged by the proverbial ambulance chasers at a time when you are least likely to be discerning and most likely to be traumatized and vulnerable. So every day, if you're watching or listening to commercials, you hear day and night commercials that bombard you with calls to enlist a certain PI or whatever attorney. So what should you do? What should you consider? What questions should you ask to make sure that you get the best possible representation if you do choose to enlist a lawyer? Today we'll discuss that and also use some very specific examples, for example, personal injury or a divorce attorney. And I guess we should preface this with, this is absolutely not an attack on lawyers in general, and certainly not an attack on Dave in particular. The idea is to help you understand and make the best choice as you have to for the situation that you're in. So, David, when someone is about to evaluate, you're a consumer as much as you're a lawyer. If you're about to evaluate a lawyer, I understand that the onus isn't entirely on you, but communication is supposed to be a two-way street. If I'm going to be purchasing a lawyer, so to speak, or retaining a lawyer, we need to communicate. What kinds of things could you give us as insights when someone's beginning the process?
So for me, the most important aspect of who you're going to hire for a lawyer is how you feel with them. Comfortable. Are you comfortable with them? How do you communicate with them? What is the rapport you have with them? Because most lawyers are going to be competent, and you absolutely want to ask them what their experience is in a certain area that you might be trying to hire them for. But once you've got to the point where you're comfortable that they know what they are doing, the most important question is, are you comfortable with them? So most attorneys will give you a free consultation so that you can come in, explain the case to them to make sure, first of all, they're comfortable with hiring you as a client, but also to give you an opportunity to evaluate them and make sure you're comfortable hiring them as an attorney.
So if someone comes in and they're in a bad situation, which is usually what happens, or not always, it could be a business situation and they're not under duress, I would imagine, I understand, that you would have to have, you as a lawyer now, have to have some degree of empathy. If there isn't that established at the first meeting, does that mean a toggle switch of go, no go right there, or is that just being hasty?
No, I think that, what do they say, first impressions are often right?
Certainly.
I think that's something that you really have to take into consideration. And I will tell you that I don't find with lawyers or anybody else that empathy is something that grows and expands during the relationship.
Point well taken.
So you need to know right up front, how do they feel about you? How do they feel about you as a person? How do they, more importantly, feel about your case? And will they take it, and will they be serious about how they handle it? But will you at the same time be comfortable with the communication that you're having with them and their ability to understand not only your legal situation, but your personal situation?
Well, I think we should delve into that a little bit more in a minute, but when someone is just beginning that step of research such as it is, many people have given referrals or get referrals, and that makes sense. I know Joe, he's been swell at whatever. If you don't know someone, very likely online, whatever, is that a good way to begin that process, David, or is that fraught? What would you say to that?
Well, two things. I think the best way to find a lawyer for your particular situation would be word of mouth from somebody you know who's already had an experience with a lawyer that will refer you to somebody. And if it's a good, competent lawyer that they refer you to, and it's not something in that particular lawyer's area of comfort or expertise. We don't really have expertise in that fact that we don't do specialization in Rhode Island, but we have lawyers who concentrate in certain areas and do certain things that they're comfortable with and won't do other things. So if it's something that that lawyer doesn't do and it's a good lawyer, they should refer you to somebody they know who does handle that type of case. So word of mouth to me is certainly the best way to have a referral to an attorney. Online, I'm not that comfortable with online because I think there are people out there who just write bad things about lawyers no matter what, and bad things about lawyers in particular that they may have had experience with. That one thing I would look at is how often does that person write a bad review about other things, because I find that there's a lot of people out there who are just negative and are going to write negative reviews about anybody and everybody and anything. So I'm not that tech savvy, so I don't know that much about it. So the next place I would go to get a referral to an attorney, if I didn't already know somebody who has had an experience with an attorney, might be to the Bar Association. I know the Rhode Island Bar has a lawyer referral service, and they have actually services that will refer you for just, I need a lawyer, here's the referral. I am in a particular situation where I can't really afford a lawyer. You might get a reduced fee referral. And if I can't afford a lawyer at all, there might be an availability through the volunteer lawyer program. So the Rhode Island Bar Association, if it's for a lawyer in Rhode Island, is certainly someplace I might start if I don't otherwise know somebody who knows a lawyer.
And of course, across other states as well, if you are new to the state or haven't had experience with a particular area of expertise or of specialization, the Bar Association in all states apparently is a very good resource. If someone picks a name, not out of a hat, but picks a name and places that call, should they expect to actually connect with a lawyer during that first call? Or is that really going to be a pre-screened, well, we'll set up an appointment first? Can you actually do a somewhat of a cursory screening on the phone before there is an appointment set up?
Most attorneys, if they have a good staff and they're busy attorneys, would prefer to have the staff talk to you, make sure it's something that that lawyer handles, and set up an appointment to meet in person. That's the way I tend to do it myself, and I think it's, I'm a kind of face-to-face kind of person. I want to evaluate the client who's coming in the door and evaluate their case in person. And I want them to be able to evaluate me in person. Now, we've just hopefully come through a pandemic. So some of those initial appointments during the pandemic and continue to be by Zoom or other, via computer appointments where you can see the person and have a conversation. But I'd rather have that face-to-face conversation either in person or through Zoom or whatever online platform you use than by phone, because you can't really evaluate somebody without being able to see them.
Good point. And once you are face-to-face with them, as you said, most lawyers will do a free consultation, which makes perfect sense, just to see if there is, at some level, a good fit. The reasonable questions to ask. For example, does it make sense that we should ask, how do you communicate as an attorney? How would you communicate with me? Would it be phone, email? Will it be with your paralegal? Or am I going to contact you directly? How does that work, David? And what should someone ask and expect?
Yeah, so understanding what the rules are between you and your lawyer for communication are important. And I think communication is one of the most important things. So I'm going to just tell you that for me, depending on the type of case and what it is, my paralegals are really, really up to date on what's going on in the case. We have a computer system that updates everything when anybody does it, and they're the first line of communication. They are very good on phone, really good by email, and also for me, depending on the type of case it is, my clients will get my cell phone number. So if they have something that becomes an emergency, and my clients are really good about not abusing that, but you call me at the office, you can email me, and you can call me on my cell phone if it's an emergency. And I will tell you that most clients, we do email because the emails go to my phone. So if I'm able to, I'll see it. If it's an emergency, though, call me.
Should most expect that in handling a case, yes, you're the bottom line, so to speak, but should they expect that they will have interchange or conversation, phone or by email, also with whoever is on that team, one paralegal or others?
Yes, and most of it is through the paralegals because they're the ones who are gathering all the information. They're the ones who need to know where it is so they can present to the attorney, me, a package and say, all right, we're ready to evaluate this. We want you to sit down and take a good look at it. We've gathered everything. You don't really want to charge somebody, if it's an hourly case, for example, my time, at my rate, for things that my paralegals are really competent and really better than me at putting together, so that they spend all the time gathering the information, putting the information together, so my time spent evaluating a package that's already put together, which can be done much more efficiently and at a much less cost to the client by doing it in that way.
Let's follow up with that a bit, David. So on that first meeting, is it reasonable to ask what the potential cost or bottom line cost will be for this such a case as it is, however someone presents it to you? Is that reasonable?
And remember, there are different ways that attorneys can bill somebody.
Yes.
So what is the method of billing that's going to be used in this particular case, and make sure you're comfortable with it and understand it. So the most well-known probably for personal injury cases is a contingency fee, which means that we'll charge you a percentage of what we recover, and those lawyers who might advertise and say no fee unless successful aren't really doing anything more than any other attorney that is taking a case on a contingency, because the fee is contingent upon the recovery. If there is no recovery, you're not successful, there is no fee. So understand those rules up front. On a contingency fee, some lawyers will say, we'll put up the expenses or the cost of the case, and if we don't recover anything, you won't even have to pay those costs back. Some attorneys will say, no, the fee's contingent, but you have to pay the costs either as they go along or at the end. So that's one way of entering into a fee agreement with an attorney. The other way might be, another way, because there's more than this, is hourly. And so, okay, what is the hourly rate? How do you bill hourly? When am I expected to pay? What's your paralegal's hourly rate? You know, do I pay monthly? Do I pay quarterly? How are these payments going to be made? And then the third way a third way is what we'd call a flat fee. And so this is what we will charge you to do this case. And we're not going to keep track of our time. We're going to do the work, and whatever amount of time it takes, you're going to pay us a flat fee, so you know what the fee is going in. The attorney knows what they're going to bill you. That can also be broken down into payments. A flat fee doesn't necessarily mean you're going to get paid or pay all at once or up front. It depends on the service and how you agree with the attorney to pay for that service.
So when someone is still asking these questions, they walk into an office, they can tell it's small, it's big, doesn't really matter. There are some discussions about a larger firm, sounds good, they have more clout. A larger firm, bad news is that you may never see your lawyer. You may have the team, such as it is, working on your behalf and not get what you're paying for. A smaller lawyer doesn't have the 5 paralegal team to deal with it. It will be just you and that lawyer, and that's better. No, that's not such a good idea because they don't have leverage or clout. What do you say to that, David?
So I don't know that there's a leverage or clout issue for a firm based on the size of the firm. I think there might be more resources depending on the type of case and situation. So if you have an international business complex deal that needs to be vetted both with United States law and the law of France, and you have a big firm that has attorneys in France, there might be some benefit for paying those fees to that bigger firm to be able to vet that more complex international case. By clout in a courtroom or clout anywhere else, I don't think that is dependent on how big the law firm is or how small the law firm is. It's really based upon how good a job the attorney can do in that courtroom. The build-up or the backdrop to getting to court is preparing a case, and so you need to have a firm that has paralegals that are competent and good and can help work on that case and present the best case possible. Yes, big firms have more resources to do that potentially. Of course, you're going to pay more for those resources. And in some instances, it's important to do that. In other instances, it's just as important or more important to make sure you have that rapport with the lawyer that you're going to be represented by and that they understand you in your case.
Thanks, that's a good point. Oh, I guess one other thing we should probably mention relative to doing one's research. Every state, while they have state bar associations where you might source and find the listing of lawyers, also each state has a listing of who's been in the bad boy pool or bad girl pool, who's been subject to disciplinary measures, actions, or whatever. Is it true that every state has that, and where would one likely go to find that other than just online and search?
So it depends on the state and where they keep those records. Some states, the Bar Association has the records and they keep them, and you can find those either online or through the, by calling the bar itself. In Rhode Island, the Disciplinary Council is an employee of the Rhode Island State Supreme Court. So they probably keep those records and can be accessed, I'm sure, either through online sources or by calling the state Supreme Court.
Good. Okay, let's get into the issue about personal injury lawyers. In some states, there's by specialty, a certified specialty. Mm-hmm. Not all states have it. Does that matter, and what weight does it have? What does that actually mean for those who are not in Rhode Island but watching this?
Yeah, so some states will have a process by which they'll certify that an attorney is competent to practice in that area. In Rhode Island, if you see an advertisement for an attorney, it oftentimes will have the disclaimer, Rhode Island does not license or certify a specialty in any area. You're either licensed to practice law in Rhode Island or you're not. We don't have a test to say I'm competent to do personal injury, a test to say I'm competent to handle real estate cases or do estate planning or workers' comp. We don't certify, and the court doesn't put a stamp of approval on an attorney for that. So again, that would be a word of mouth type of thing. But there is no specialty, and there's no certification in Rhode Island for that.
But you, as in the interviewing process, you as a
consumer,
on the consumer side of it, you might likely ask how many years or how long or how many cases have you handled in this particular specialty? Do you ask what your outcome or report is? What percentage of your personal injuries went to trial versus settled? Are those valid questions?
They're all valid questions. And you want to know, do you handle these kinds of cases? Are you competent to handle these kinds of cases? Have you handled these kinds of cases before? If they're personal injury cases, have you tried a personal injury case before? Now, most cases do not end up going to trial, especially with alternative dispute resolution, as we've talked about before, mediations and arbitrations. But have you handled a mediation before? Have you handled an arbitration before? They're not, if you hire an attorney that's going to handle a personal injury case and they haven't taken a case to mediation, arbitration, really even trial, then you might want to really think about that a little bit. But again, first and foremost, are you comfortable that they understand the area of law that you're hiring them for? And are you comfortable with them as a person that's going to be representing you?
And I guess others sometimes ask, have you ever taught others, or have you had an occasion to share your information with others? Do you just sign up clients, and if you don't get them to settle, do you pass that off to other people? Are those legitimate questions to
Sure.
ask, and at what point do you ask those kinds of questions?
Yeah, I would ask them at the beginning. This is my case. I want to explain my case to you. Are you interested in my case? And then, if you're
Good
going to
point.
take my case, are you going to be my attorney? Or is it going to end up going to another firm that tries cases and you just bring them in and try to settle them on personal injury cases?
I'm not sure that all of our viewers have been aware of that element of it. So often you'll hear, beware, many lawyers are advertised that they'll settle cases, but they settle them less than they're worth at times. Whether they're a large firm or not, volume still matters. A lot of small adds up to whatever it adds up to. So how can you be sure that you are not being, I don't want to say sold down the river, but that you're not being, your case isn't being evaluated and settled for less than it's truly worth? How could someone know that, especially at the outset of that interview process?
So I'm not going to say that because a lawyer advertises they're going to settle for less. Every lawyer handles cases the way they handle cases. You always want to try to have the best possible outcome, as we say at the beginning of the show, for your clients.
Yes.
So I'm not going to paint with a broad brush. But what I will say is that you'll know right at the very beginning if you're hiring an attorney that handles an awful lot of cases and it's a lot of volume because that's how they do their business, that's their business model. Am I going to be dealing with you or am I going to be dealing with another lawyer? Tell me about that up front. I want to know and how many other lawyers do they have? So is there a pecking order of my case is this big, it's going here, it's bigger, it's going there?
Good to know.
My case is important to me. I want to know that it's important to you as well. So, your first impression, like I said, is often right. You'll have an impression of what they're going to do and how they're going to handle it. And if you're comfortable with the person you know who's going to end up handling it, no big deal, fine. If you're not, you should interview other people. And maybe you should interview more than one attorney anyway if you don't have already an existing relationship with that attorney and know you're comfortable with how they handle cases.
I think these questions are very interesting. I'm not sure that everyone has had an occasion to think this through. And of course, to be aware of it before it happens always puts you in a better place. Address this issue, if you would, David. When it comes to insurance companies that you're going to be dealing with, there is a thought that insurance companies keep track of the firms and who settles for what, regardless of whether it's a factor of size or more importantly, I guess, as you pointed out, the lawyer himself or herself. Whether they're known to get the higher amounts, the lesser amounts. Do they keep track of lawyers? How would you know that? I don't know if you'd know that. And then secondly, it does make sense that if you as a lawyer are known to be one who settles quickly, then doesn't that automatically give that insurance company leverage that this person's going to settle quickly, wrap it up, get out of town, and not have to deal with going to court? What do you say to that, David?
I don't know if insurance companies do that. If they did, it could be, as you say, some leverage, but I know as a lawyer, I keep track of how insurance companies evaluate cases.
So good point.
And I know that if I have a case with a certain insurance company, that more times I'm going to end up putting that in suit than not, because they're never going to offer me a fair amount of money before it's put in suit. And so I keep track of that. So maybe they do the same. And that's maybe one of the reasons you should ask your attorney if he's ever tried a personal injury case before, because if he has and they keep track of that, they're going to know, well, this lawyer will try a case. So if that's a factor that they put in what they're going to offer, yeah, maybe you should know about that. I can't say that that happens, though.
It's a very interesting point. I mean, I think that when you hear that someone has heard from an insurance company, they're ready to settle right away, and they haven't offered a number yet, and at the same time that consumer is going to see lawyers, it would certainly give them some idea about what that process is about. And I imagine that getting to have a conversation with one lawyer, two lawyers, maybe more, flesh that out would certainly make a difference. Now, you were talking earlier about how many do settle out, or there's mediation or mediation. Let's go with that for the moment. If someone is more likely to settle cases, then it certainly stands to reason that you'd want to know how lawyers feel about going to trial in general. Many of them say, well, can't you hear them? Well, you know, it's painful to go to court. It's aggravating. It takes time. It's whatever it is. We'll take care of this quickly for you. Is that a bad sign? Is that a bad sense of communication? Or is that, no, clearly this is just something that should easily be wrapped up? How would someone in distress be able to judge that, David?
Well, this is what I would say. Two things. First of all, that is probably not something that generally is discussed at the beginning,
right.
But it could be and should be. Mm-hmm. And so I'm not going to say that every case needs to go to trial, because most cases shouldn't.
Certainly.
But I think the insurance company needs to know that you have a lawyer that is willing to take a case to trial. And like I said at the beginning, I don't know if they track whether or not you take cases to trial as an attorney, and it factors that into how you're going to settle. But I have had discussions with adjusters from insurance companies about, you know, I've tried this case before, and I'm not this particular case, but a case just like this. And I'll try this one too if you're not going to give a reasonable offer. And then what often will happen is they won't give a reason. I told you I track what these insurance companies do, and I know who will settle for a reasonable amount and who won't. And so when they won't make a reasonable offer right up front, I'll put it into suit. Doesn't mean that case is going to end up at trial, because oftentimes either through the mediation process or the arbitration process, you're going to get to a point. And what they'll tell you in mediation, oftentimes, the mediator, is, well, remember, this is a guaranteed number. You're going to get this. You won't have the cost of going to trial, which might mean bringing the doctors in and paying them for their time to testify and all these other things. So yes, those are factors that might sway somebody to say, yeah, this is a pretty good number, we should accept it, versus going to trial. But you have to be willing, and the insurance company has to know that your attorney is willing to go to trial if you're not going to get to that zone where it's close enough that you would be better off settling it than taking the chance at trial.
Yes. So I guess you really do want to ask, do you take things to trial, or are you ready to see what kind of reaction you get to that? Is it true that as time passes, if you haven't settled one of those cases, the case value decreases? Would that necessarily be the case, or would it likely either stay the same or maybe even increase because you found that there are new things, new wrinkles that have been unfolding? Yeah. Is there a black and white on that, David?
No, and it can go both ways. Mm-hmm. So as your case unfolds, and depending on the type of case it is, but if we want to stick with personal injury on it, I try to find out as much from my client as I can about their case and their previous medical condition, because that's what can factor into a value of a case. So if someone has a back injury, but they'd been treating for a back injury for 2 years prior to the accident, and were on their way for treatment the day of the accident, might have an impact. Now, of course, I can argue that it actually makes the person more vulnerable to more injury than someone who had a pristine back and just had a sprain, whatever. But those kinds of factors, as they come out in discovery and what you find out about the case, can maybe make the case become less valuable, or it can make the case more valuable. So there's no black and white answer to your question.
Good to know. Many questions asked and answered here. We didn't get to touch on the divorce lawyer situation, but we hope that this has been helpful to you in making your decisions and the various things you need to consider. Please do continue to watch Law Matters. As we say, it matters to you. Thank you.